Hi, my name is Karla Mansur. I'm a divorce and family law attorney in Concord, Massachusetts. If you're going through the divorce process right now, you know or have heard of the Cavanagh case, most likely. The Cavanagh case came out in 2022 and changed the entire landscape of how we calculate support in Massachusetts. Prior to the Cavanagh decision in 2022, we used to consider only the first $400,000 of combined income for child support purposes only, and then any income over that amount we would use to calculate alimony. The Cavanagh case completely upended that and said you could use the same income for both support orders. So Cavanagh instructed us to run alimony first, add the support obligation to the recipient's income and deduct it from the payor's income, then use those gross figures to run the child support guidelines. So essentially using the same income twice to calculate two different support obligations, which is not how we had ever done it before. You're then supposed to also just run child support and then an alimony calculation after that on the additional income. And then the third step was to figure out what is the tax consequences of these different support orders and determine which is most equitable. Most of the judges in the probate and family court in Massachusetts are using the Cavanagh analysis, and that's typically alimony first, child support second, and then what are the tax consequences. Because the payor will generally have a much higher tax bracket than the recipient would, and they want to look at, well, what are the actual after-tax dollars? In a lot of cases, I can tell you it doesn't come out to be very equitable. There's a certain income bracket that makes it entirely unfair. It's around $200,000 to $400,000 in income. A payor in that range is oftentimes, under the calculations used under Cavanagh, going to end up paying more of their net income to the recipient than they're actually going to retain. And we have other case law that kind of interjects and says, hey, wait, a spousal support order or child support order is not meant to be an income equalization order. In a lot of cases, this Cavanagh analysis is even further than income equalization, and the recipient ended up getting more of the income than the payor did in those circumstances. So that's Cavanagh. That changed everything. We've been working with that framework now for the last 3 years. Well, lucky us, Cavanagh too just came down on July 9th and kind of further complicates the landscape. The initial appeal was remanded to the trial court judge to make determinations about income, using this analysis that the appeals court thought was appropriate. Well, the judge did that, and the appeals court is still not happy with that decision. So they've issued a new decision. Now that new decision takes things a step further in a way that's potentially cataclysmic for a lot of people. In the new decision, the appeals court is now saying the payor, in this case the husband or father, was still working, earning income, but as part of the divorce he had also taken a larger share of the 401k. And that was presumably so that the wife could stay in the house, in the marital home with the 3 kids, and instead of taking the equity out of the property, he agreed to take more in the terms of the retirement. Well, the appeals court instructed the trial judge to go back and look at this man's income that he's earning on a 401k and add that to his income. That's potentially, that's problematic in a lot of ways, because for most people, if you're 59 and a half or younger, your 401k isn't something you're allowed to touch, especially if it's an active 401k. And it's certainly not something you're allowed to take money out of without there being a penalty. So the income tax, because it's pre-tax income, you'd have the income tax, but then you'd also have the 10% penalty for early withdrawal. So it's hard to understand, but basically the appeals court is saying that the income that your 401k earns, even though it's not something that you can touch, may potentially be added to your income to use to calculate your support obligations. It's unfair to both parties if that's the case, right? You can think about it in terms of the payor, right? His income goes up by, $20,000 in a year, and that gets added So the support calculations go up significantly. But also, if you're the recipient and you took, retirement money, your income, maybe you're only earning $600 a week, minimum wage, but you have this retirement account that, again, you have no access to, is earning money at $20,000 a year. Well, your support's going to go way down because of that. So at this point, we don't know how the probate and family court judges are going to feel about this decision because, it creates a whole new class of income. We don't know how they're going to apply it, but potentially it's problematic. And the appeals court also said in their decision that this man, it was the payor in the situation, he had taken a larger share of the retirement assets, that, for the purposes of alimony and child support, you can use assets that were divided as part of a divorce to calculate child support. You cannot use them to calculate alimony. It's called the impermissible double dip. So the trial court judge, knowing this, said, okay, well, only 50% of this man's retirement account will be used for the purposes of calculating his income. And the appeals court came back and said, well, what do you mean 50%? The wife only got 20% of the account. So what does that mean for us as divorce practitioners and you as divorce litigants? It means potentially that we can't be doing these types of creative solutions where we find a goal, and let's say it is to keep mom in the house with the kids. And in exchange for you not taking all that equity out because you can't get qualified for a mortgage at 7% and pull all that equity out, your options are limited, because if you take more of that retirement account, potentially down the road you start paying support on it. Whereas, the other party who maybe kept the marital home, it's appreciating, but it's not showing up on your income statements. So the assets that you take as part of the divorce might potentially be more important than they've ever been before, based on what kind of income they produce. And that's really significant with the 401k, which is different than the brokerage account, for example, where, if you had to, you could sell the assets, you could use it to pay support, but with a 401k, you can't. With an active 401k, the best you can do is take out a loan at pretty significant percentage rate. So you're left with that option, or taking out early, paying income tax and the 10% withdrawal fee. And in this instance, like I said, the judge said 50% of the account should be excluded as marital, and then the rest could be used for purpose of calculating child support. The appeals court said that the burden was on this man to prove how much of that account was marital, because they pointed out the fact that the wife only received 20% of the account. So that complicates things further too. Prior to Cavanagh 1, we didn't need experts to help us get involved and calculate the tax consequences after divorce and what that would look like. But now it sounds like we're going to need them even to just prove to the court what portion of potential assets that might be producing income were marital and not marital, to try to figure those things out. So it complicates the case. Just an ordinary alimony and child support case that used to be fairly straightforward has become much more complicated, much more involved, and potentially much more expensive.